market simmered. In 2021, it mushroomed, it exploded. It
Right,
became a
because
market.
things changed. Prior to 2021, there weren't any nil payments that were made. When
But there
2021,
were-
the handwriting from several sources became on the wall and they started making them, and now they're included. But what does that have to do with the $22 million cap?
If I may remind Your Honor, at the time, the senior marketing person for EA said, I would have paid the athletes, but for the restraint imposed by the NCAA. And so once that restraint was removed, that market grew. And as it grew, it mushroomed to a free market between the third parties and athletes, which was a source of revenue to those athletes. Now we take the cap. What does the NCAA control in the cap? It controls the input to the cap. It controls the formula to the cap. It controls what gets included and what gets excluded. It controls the offsets to the cap. And then most importantly, it controls the collective participation in providing revenue to the athletes, which gets offset to that cap. Now,
I'm sorry, the what?
the collective revenue distribution to athletes, which gets offset under the cap. Because in terms of the revenue projection that the cap counts against, they reduce that by the amount of money that an athlete receives by collectives. So what is involved here? This business understands what it needs to control. Now, with regard to the cap itself, that would be judged by the rule of reason. With regard to the interference, as Your Honor pointed out at the beginning, of the right of the collectives to freely engage in trade with the athletes, that's a per se violation. That is not covered by the Board of Regents case, or the O'Bannon case, or the Alston case.
Did you brief that?
No, Your Honor, it just came up in the intersection argument and in the discussion of Your Honor with regard to the other issues dealing with accountability and the restraint on the revenue dealt with caps. But the action against the collectives is more like a group boycott.
You're talking about things that weren't briefed. I read these briefs. I read them a couple of times, and it's going to be hard to switch over to something that wasn't raised.
Your Honor, whether or not it's focused on a group boycott by the NCAA of the collectives as a whole.
And collectives doesn't help me. It's whether they're
The boosters,
whether they're associated with the school or are they not associated with the school? Are they University of?
no, they would not be university affiliated. That was one of the measures, that the NCAA used for the back payments. They took the university affiliated, endorsements, 150 of them, and disregarded the open door endorsements recorded, on the internet, which was 150,000. At this point, there is no question, Your Honor, that there are billions of dollars paid out in NIL to athletes, not through universities, for their NIL.
I've lost you. You're arguing now that the NIL rules are per se violations? Is that?
The collective rules, the attempt by the NCAA to control the payment by non-university NILs, yes, would be a per se violation, or should be at least.
Okay, well, if I have to, I'll have this briefed, but at the moment, I'm not really getting your drift. We're talking about the 22% pool cap, and then you switched over to the nil caps, and I don't know if.
And what's interesting in that, Your Honor, with regard to the 22% nil cap, it offsets
Pool cap.
the pool cap. It offsets the nil that are paid by collectors, not through universities, to the athletes.
I mean, the nil offsets the pool.
Yes.
I
So they're
can't remember
control-
whether it does or not. I guess we'll find out, but
They're
let's say
control,
it does, then what?
they want to control the market. That's the essence, of this new proposed settlement.
Well, I just have to separate them out. Do you want to talk about the 22% pool? Or do you want to talk about nil? Because I'm not following what you're saying the connection is.
They're all, I think, as the NCAA council said, intersected. And in judging whether or not there's an unreasonable restraint of trade, what does this proposed settlement attempt to do? It attempts to eliminate any access by athletes of revenue outside of what the NCAA provides. And that is the control that the NCAA wishes to exert over this market.
I'm not sure that's true, but okay. So you're saying that all of the nil money, whether it be from associated individuals or unassociated individuals, is taken off the pool cap? that what you're saying?
Reduces the amount of money, or it counts against the cap.
I don't think so. And if there is, there's a limit to it, but okay, if that's the point, then I'll look into it.
On the whole, Your Honor, what is concerning here is what is the NCAA attempting to achieve after 100 years of exploitation? Out of the goodness of their heart, are they now saying, we were wrong? We have to provide the athletes something in return for, losing the right to collect on their NIL? Because that's what the original House case was about, NIL. They want to
And that's the
control
original
they
Alston
want to
case.
control the market.
Original Alston case.
Yeah, Alston, excuse me. They want to control the market.
Okay, but that may be unfortunate, or it may not be, I don't know, but my job is to look at all of these provisions separately and decide which, if any of them, are antitrust violations that don't comply with the rule of reason, and if they are, can they be fixed? And if they aren't, the settlement's approved. If they can be fixed, great. If they can't be fixed, then we don't approve the settlement. But
I think that's what I started with, if the settlement is drafted. And I picked up on the comments by the NCAA council that all of the elements are intersect. If they all intersect, each one can be judged independently, but they have to be judged as well as a whole. If I may, for example, Dr. Rasher.
well, you've got a couple more minutes, so if you had some sort of overarching points you wanted to make.
Dr. Rasher said that his declaration does not offer an economic analysis to assess all of the competitive effects of this settlement or to balance possible anti-competitive harm against possible anti-competitive benefits. That's true. No one has done that.
Well, I don't know that that's the test. Is it a balancing test? For
Well,
approval
Under
of the
rule of
settlement?
reason, it certainly is, Your Honor.
For each individual thing, yes.
Exactly. And then as a whole, because the settlement does not apply only to each individual component. It applies to all of the components as a whole. And so Your Honor has to make a decision as to whether or not the settlement as a whole involves anti-competitive effects that outweigh any pro-competitive benefits, which have not been identified for the 365 schools, 195,000 athletes, 24 different sports divided into, two genders. What is the pro-competitive benefit, of the caps, for example, in women's sports? What is the pro-competitive benefit on non-revenue sports compared to revenue sports? These are the issues that need to be determined if, in effect, the settlement does infringe in those areas with respect to anti-competitive effects and alleged pro-competitive benefits, if any. One of the things, again, Your Honor, I'd like to emphasize is that the settlement makes no commitment whatsoever. It says every school is free to do what it is they wish.
Well, that's the market, right?
No, that's not the market.
You can't force them to pay something they don't want to pay if they don't have to pay it, and it's not any sort of.
Precisely. So there's no bottom on which to measure this. There is a market outside that they're trying to reach. And that is the NIL that's being paid to athletes now, because that is their effort to control that licensing provision and to offset the cap.
Okay, well, again, we'll find out what I just can't remember the details of that right now. There's some kind of $2.5 million.
That's on new scholarships.
Okay,
In short, Your Honor, given the fact that there is no floor, unlike in professional sports, but there is a cap, and the professional sports that they cite are not viable benchmarks because they're all collective bargaining agreements with a single sport, with limited number of teams and limited athletes and all men.
let me ask you this before I tell you your time is up. What's your view on the class certification question?
The case of
The class certification question, whether a class can be certified that includes future members and whether their future claims can be released? You have any thoughts on that?
I think, Your Honor, again, the Supreme Court decided that, in the silicone breast implants cases, those that are not yet class members deserve to be separately represented. Those individuals, some of whom are high school or junior high school, really have no knowledge, of what
So
this
can they be in
settlement
the class
will
or
do.
not?
Excuse me?
Can they be in the class or not? Can they make a valid release or not? I'm sorry to put you on the spot. You don't have to answer if you don't want to.
I don't
just
think so.
curious.
I don't think so, Your Honor, because it's difficult to understand how they received notice of this and fully understood it. These are, adolescents with no agents, to help explain, the intricacies of what's going on.
Are you okay, Renee? Let's give Renee a moment here.
No problem, Your Honor. Thank you.
Okay, I'm sorry. I didn't mean to put you on the spot on something you weren't.
No,
addressing. And I do need to.
I am very concerned, about the rights of those yet to be inducted, into the college sport arena, as to whether or not the notice to them, is fair and adequate constitutionally.
Okay,
Thank you, Your Honor.
thank you. How long have we been going all together now? It's going to give the court reporter. Should I take one more or do you need a break now? Okay. Ms. Rutherford, is it?
Yes, Your Honor. Okay. Good morning, Your Honor. Laura Rutherford on behalf of Objector Emma Rutherford. I appreciate the opportunity to speak today. I know you have a lot to consider. I'm really just going to hit the rules and the black letter law that I think really hasn't been discussed yet in the hearing. But I did want to respond before I do that, just 2 points. The NCAA at AA has said, they want an answer. Should we settle or should we continue to litigate? Those are not the only two options. You could go back, make a different deal. I'm a class action defense lawyer by trade. I get sent back all the time. They could do that if they really wanted a deal that made sense. On the notice, I think that we didn't object on this, but I think it's a point worth mentioning. You go to the website, just big bar, make your claim for money. You know, it reads like you bought some bad eggs and you want to get paid for your refund. It doesn't really explain to people the true implications of this settlement, especially as, Mr. Hosfeld pointed out, these are adolescents, okay? My daughter's lucky enough to have a mother for a lawyer, but not everybody is. So she didn't understand what she got. And I think it's also
for a mother.
Pardon?
A lawyer for a mother.
Oh, what did I say? A mother for a lawyer? Did I screw that up? Yeah, lawyer, thank you. I appreciate that. Thanks. And then I think, I don't recall seeing the distinction between sort of former athletes and current athletes. If you're a former athlete and they're saying to you, hey, get some free money, great. Current athletes, they may have reservations. I know my daughter certainly did, and I'm sure other athletes did too. So I just think those are things to consider.
I didn't follow that point.
Oh, we don't have
offered more money, they'll accept it.
It's not that it's.
What else?
I apologize, Your Honor. It's not that it's more money. It's just the difference between a former athlete, so someone who's not currently on a team, but who was, and a current athlete, someone who's on the team right now. And we don't know the distinction. We don't know the number of claims made in those two groups, because I think it's logical that if you're a former athlete, you have absolutely nothing to lose by making a claim. But current athletes, they might have reservations. And there's declarations primarily submitted by the Molo firm on that point. People were scared to come forward.
And so, how does that fit into any of the?
Well, I believe it was the plaintiff's lawyers who were explaining that this settlement had wide support. Oh. And I think it's important to distinguish between those two groups before we really evaluate how supported the settlement is. That's my only point.
Well, it's a pretty major number.
It's the claim, sure. But again, if you go to the website, it's a very easy, get your money. If I didn't care, I'd get money too.
Okay.
The last thing, I think we need to just introduce my argument, which really focuses on the harm by athletes. And this isn't an unfairness argument. This is a harm argument. By just stepping back to look what an injunction does, right? An injunction is here to prevent harm. It is not there to create new harm. And the plaintiffs took issue with our citation to Dukes, which is a United States Supreme Court case, where we said that injunctions are supposed to benefit everybody. And that's because that's what their purpose is. People don't run to court because there's good in the world and say, oh, Your Honor, there's a lot of good happening. Please issue an injunction and stop it. No, it's the reverse. There's harm in the world. So people come to court and say, issue an injunction, stop the harm. Here, this injunction is creating the harm. So this
creating some harm for some people.
Yes, exactly.
And it's pretty hard to have 390,000 people and have it create no harm for any of the 390,000 of them.
When there's a B2 class, Your Honor, I submit that it's completely not allowed. And I've got the case law to support it. The court's job in approving this settlement under 23A necessarily involves an evaluation of the factors of 23A, particularly A4 adequacy. Your Honor has already discussed that. And the payment card case, which we've all cited, has two factors to inform whether or not the representatives satisfy 23A4. Absence of a conflict and assurance of vigorous protection. Okay, neither of these factors has been met here, Your Honor. And if you look at this case holistically, which the plaintiffs and the defendants are urging you to do, you could say, sure, $2.75 billion. That's amazing. But you could literally buy yourself out of anything. You could certify anything because it's a big number. And that's not what the law allows. The conflict, it's really admitted here, right? No one said in their briefs that there wasn't a conflict. Instead, they said it's a compromise. But the cases that we cited attack that very issue, particularly the airline stewardess's case, where the lawyers made the same argument. This is a compromise. Some of the pregnant stewardesses.
What case was that?
Oh, I'm sorry. It was cited in our opposition papers, Your Honor. I can tell you. So on page 5.
That's all right. If it's in your brief, I'll find it, but
Sure.
I just don't remember it, and I thought you might know the name of it.
No problem. Yeah, it's Airline Stewardesses Association Local versus American Airlines, 490 Fed Second 636.
Okay, and what was the conflict?
It's a great case. In that case, There were female stewardesses who were pregnant who got fired because they were pregnant, because, back in the day, people thought they wouldn't be able to fit through the aisle on the plane. So they had their union file a class action lawsuit, which the union did, and settled. And the stewardesses who were unlawfully terminated or wrongfully terminated sought reinstatement. And because this was a union environment, it caused other currently employed stewardesses to be bumped. So they were going to have less seniority. And the court found that conflict in and of itself meant that a class cannot be certified under B2. Because as Dukes explains,
A class of current employees versus former employees, or
People
class
who've
of
been-
pregnant employees versus non-pregnant employees?
No, just women. So it's the women who were pregnant, who got fired, and they wanted to be reinstated to American Airlines. But that reinstatement meant they said, well, I want to have all my seniority back. So what happened is it bumped the current women or other employees who had less seniority, and they said that's not fair.
And were they in the class?
Yes, everybody was in the class. And so the court said you cannot have a B2 class in that scenario because of the conflict.
Okay, so they had to divide it between,
It's not clear what they did after that. They basically said the union, like the plaintiff's lawyers here, couldn't represent both, which is basically our argument, because the union in that class was inadequate
and
to represent the conflicting class
what
members.
you're drawing to this case is what? Who's
The winners, the people who are going to get paid in the
We're going to
forward-looking,
define a class. What class are you're, I guess,
the
saying
injunctive relief class
just the injunctive relief class alone by itself?
cannot be, right, I say it does not meet A4. Because you've got athletes that are getting paid from the settlement, and then you've got athletes that are going to be
Athletes
cut.
who are getting paid aren't, that's the past money. That's
No, they're
damage.
going to get paid in the future, right? That's part of the deal.
Well, you said the past, but okay, so we're talking about future student athletes. who
Yeah.
will get paid in the future, perhaps. And who else?
And anyone who's getting cut from their teams. Because as the NCAA said, the payment to the future current athletes goes hand in hand with roster limits.
So you're talking about roster cut.
Yes, I apologize if I didn't make that clear.
Okay.
Yeah, I'm focused on the
So-
conflict caused by roster limits.
The question of the roster limits is the question of whether there are two separate classes that have to be considered as two separate classes, or are they people who sadly didn't get to keep a roster slot that they thought they might get?
Correct, because there's a conflict. And the Prickett case, which we cite in our brief as well, states that a class cannot be certified under A4 when its members have opposing interests or when it consists of members who benefit from the same acts alleged to be harmful to other members of the class.
Okay, so
Now-
one way might be to define them out of the class.
Probably. Yeah, there's got to be some remedy. The way it stands now, it's not workable, in my opinion. And I think that the settlement approval of the settlement needs to be denied for that reason alone. And Prickett says that. I mean, all the cases that I cited say that. And I understand the plaintiffs didn't like Prickett and the other cases that were class certification cases, but I think that those cases are actually more relevant because those were all opt-out classes. So if the courts in those cases, which allowed class members to opt out, denied certification because of the conflict, then this court must deny the settlement based on the conflict because the class members can't opt out. And the payment cart case supports this. There's a great quote. I mean, it says,
What would you propose to ameliorate the disappointment of the people who lose their roster spots now?
well, Your Honor, I mean, I wondered if you were going to ask me that, and I feel awkward because I'm not the NCAA, and I'm kind of in a conflict myself. But I do like the grandfathering idea. Why not grandfather them in? It's a great idea.
And
I don't know
that would solve the problem. It's
I
not a
believe it-
continuing problem. It's only a problem of the people who are in the interregnum right now.
Okay.
Okay.
As Mr. Molo pointed out, these people are losing stuff.
Okay.
They're giving stuff up for the others.
Okay. Did you have any other points you wanted to make?
I did, and if it really,
Give you another couple minutes to finish
Oh,
up, but
am I already at 10?
you're.
Okay, I got a lot to
Yeah.
cover, Your Honor. I think it's important to put a point on the conflict, right? As we stated,
Which conflict?
between the class members. There's right?
The
There's those that are
roster
getting cut, and then there's those that are going to not get cut,
Okay.
right?
the roster.
Now, and I had this illustration, right? Let's say, Your Honor, you wanted to hire me to,
I need to be it to be a shorter ending.
I'm trying,
And start
I'm trying,
a new story.
right, it's not a long story, but I think the point is worth making. If you hired me, Your Honor, just to sue the NCAA for your name, image, and likeness, or to get money, and I came back to you and I say, Your Honor, I have the best deal, $2.75 billion. But here's the catch. You're not going to see a penny of it. That is not adequate representation. And that's exactly what's happening here. As the court and payment card stated, when there was a conflict in that case, the conflict was exacerbated because the members of the worse off B2 class could not opt out. The B2 merchants were stuck with the deal and the representation. So in any other situation, with all due respect to the plaintiffs and how hard they've worked, I get it, but you would not continue that representation with that lawyer. You'd fire that lawyer. These people who are going to get cut from the roster spots, they're in the class. They cannot opt out. They deserve more due process. And that's what the case law says.
I'm not sure I mean, I would think about that, but I'm not sure how they could opt out.
Well, they can't. That's the problem. That's why the settlement has to be denied.
We could say you may opt out of the settlement.
No.
What would they say? How would that work?
Exactly. It's untenable in this structure.
They
trying to,
can't opt.
correct.
It could not be set up in a way that would allow them to opt out.
which is a violation of due process. That's my point.
That all B2 classes are violations of due process?
Not at all.
No.
The ones that are harming people. That's what Duke says. That's what the Weingarten case says. And I need to point Your Honor to a really good case. And because they said they didn't like, I think it was Weinberger, because they said, well, Weinberger's not a settlement case. But there's a great case out of the Eastern District of California called Arnold versus Sacramento Doubletree. And in that case,
Okay, we'll take a look at that one.
okay, can I give
Thanks
you
very
the
much.
site?
No,
Oh,
we can find
okay.
it.
Your Honor, I did have an argument on the
I need to cut
state.
you off here. It's
No, I
past
understand.
time for my reporter's break and you've had your time.
Okay.
I need to move on.
Thank you, Your Honor.
Okay, so we're going to take a break. What I'm going to do, I had a list of people in order which had the non-represented objectors last, but they may have other things to do like classes or meets or things. So what I'm going to do is call next after the break, call the non-represented objectors and then go back to the list of represented objectors, which would start with Mr. Bradford after the students. Okay, so 10 minutes.
Court's in recess.
Okay, so we're watching, if you're with me here, we're watching the hearing, which is the NCAA collective settlement, which today being April 7th. For those of you that follow me on a regular basis, obviously we're talking about roster sizes, roster cuts, name, image, and likeness. We're talking about a lot of topics under one settlement umbrella. So there's a lot to digest here. And for those of you that are watching, I will put my glasses on because this is an exception. Yes, Russell, Mr. Cormier, Mr. Bernardian, yes, the recruiting classes for 2025 are much smaller and will continue to become smaller over the next few months. I would say that May and June, as we move closer to this kind of settlement
Well, which door can I get out of?
finalization, we'll see that. You know, what I want people to know, Bob, thank you for watching in Sudbury. Scott, yes, it's a very good argument. You know, fortunately, you have, you know, parents that are also attorneys that are accurately representing, and I want to talk a little bit about that. there are a lot of parents that have legal backgrounds that have asked me these questions, and I'm certainly not one to venture
So
into
we are in
the
what's
waters.
supposed to be a 10-minute break
Um,
here. The first break of testimony after about an hour and 45.
So I do want to make this point, and that is the crux of the argument is if an athlete loses a roster spot, and let's say the rosters were to go from 40 to 34, well, it's no fault of their own. They were recruited under the current system, and I think they're looking for a grandfathering process so that you don't see a mass exodus of student athletes, this spring in all sports, not just youth baseball, but basketball, obviously football, soccer, lacrosse, etc. And also, there are damages that are caused because those athletes that are cut and looking for new schools, they lose out possibly on the Division I financial portion of the settlement if they have to go to a Division III, a Division II, possibly a JUCO. A lot to unravel here. But I think the three biggest topics that parents are looking to get answered in a relatively short time period, and I'm sure as this goes on, and I find it fascinating, and I had a parent send me a message, thank you, Monique, am I listening? And I'm like, you know what, I'm listening, I'm watching. I'm not as tech savvy as other people, but I do think that this is a wonderful opportunity to share so that you can ultimately hear, whether it be live or in a pre-recorded format at the later date, how this legal decision is being formulated. It's clear that the judge is struggling with both the current, the former, and the soon-to-be college student athletes who are high school athletes currently, and the damages, with regard to A, name, image, and likeness, B, roster spots, and then you go back to the essence of the case, which is the O'Bannon case versus EA Sports, and that is the video games and other similar products that are currently being created. So there's a lot to unravel here. I do think that you are going to see high school students greatly affected by this. I do think there is going to be something that I don't think a lot of coaches anticipated. I know college coaches are aggressively working through and hoping to get a larger roster as it pertains to baseball. I don't think anyone finds it in the sport's best interest to go from the current number of 40 to 34, nor do they feel comfortable going from a fall roster of 38 and then having to notify 4 student athletes that they're not going to have a place in the spring roster. That's really difficult for college coaches. And, I get a lot of people that say college coaches, they're very cutthroat. These are human beings, and they are not going to enjoy that particular part of the process, trying to get from 40 plus to 38 and then subsequently 38 to 34. And I thought enough of that topic rather than to wait for tomorrow evening. I thought that, hey, this hearing is being streamed live. And I thought that this is something that should be shared with parents. And I am getting a lot of comments, and I am getting a lot of text messages. And you're very welcome. I'm glad that I'm able to offer the stream. One of the questions that continuously comes up from a lot of parents that are frustrated, first of all, this goes back 10 years. So, the settlement was, just recently agreed upon, and now it's looking to be finalized through the court system. But I believe this would go back through 2016. and if you go back through 2016 and all of those athletes, the compensation, that will go to those athletes, I'm sure there's going to be other athletes up and through, maybe the early or mid 2000s that will come forward. Then you're going to have litigation potentially from high school athletes. There are a number of high school athletes that are finding out that they're probably going to be classified as walk-ons. And given the opportunity, therefore, it adds remedy to the high school athlete. They get the opportunity to go to school. They get the opportunity, but I don't know if their scholarships are going to be applied. And that's a big bone of contention. So a lot of parents are asking me, and of the college coaches that I chatted with or texted with or spoke with, over the last 24 to 48 hours, they all see this as a potential messy situation beginning in May and going into June. And I think a lot that ends up being decided here this week. I don't think we're going to get any final decisions today. I think there's going to be a lot of these topics tabled and taken under advisement, and the judge is really dealing with, the complexity and the scale of this case from a legal precedent perspective is mind-boggling to me. If you're an attorney, I would love to hear your opinion on this. I just think that I don't think we as parents, or I really, can wrap my head around this is a verdict or this is a judgment that will span decades going forward. And I think it may go back. And as the mother of the student athlete, the attorney that spoke, who's representing the high school athlete here? Who's representing the athletes that will ultimately be asked to leave school or cut from a roster spot due to litigation? There's a lot of damages here that I'm sure there are attorneys that are licking their chops waiting to get at something like this. But, NCAA sports, what is the reasoning to even remove spots? Guessing less money? Yes. So again, here, and I think this is a good point that is made here on my stream here via YouTube, also X, formerly known as Twitter and Facebook. Roster spots, you have Title IX, and you have rosters that have been reduced, as is the case with baseball, also with football. The crux of this, if we look at it from a football perspective, imagine being a potential, a current Power 4 conference team, and your roster on football with injuries and so forth might have been 140. Now you have to get it down to 105. Wow, that's a lot of bodies. And a lot of athletes that are working through injuries, redshirt years. Again, the complexity is mind-boggling. So when you start to talk about baseball, for instance, you go from East Coast to West Coast, and for years, when it was a 35-man roster and transfer rules were stricter, and they've changed and evolved several times over the last 2 decades. This is going to be, now I have to reduce my roster. What about potential injuries, especially with regard to pitching? So the reduction not only hurts current college student athletes, it hurts potential future college athletes that are currently in high school, not only just the 2025 class, but 2026 as well. The other part of this dynamic that I think really needs to be discussed, and I don't think we are diving deep enough down the rabbit hole, is it's coming. A professional division is definitely coming to college athletics. I can't tell you how this has been an opinion. I've had it for 2 years. Those of you that have followed me, I am telling you, it is my personal opinion that by the year 2027, college, the big boys, and I'm talking about, many schools that are currently in the Power Four are going to leave the NCAA umbrella. There's going to be too much money. Remember, the football contracts for television broadcast rights end in 2026. Important component to this. It's critical for you as a parent to understand all of the big money television agreements with the conferences, the NCAA. The NCAA owns the rights to March Madness. The college football bowl structure is by the football conferences as we currently know them. Baseball, the College World Series, another NCAA right-owned entity. So you have football on its own island, and then you have basketball and baseball. Their championships are kind of NCAA owned and run and operated. My opinion is we're going to see a professional division because it's all about money. Please, let's stop kidding ourselves. The industry as a whole, all the way down to youth baseball, all the way up to the sport of Major League Baseball, it's all a professional, money-driven business. And I think in 2027, we are going to see a full-fledged professional minor league division that is going to be created. And I'm going to get into a deeper dive on that tomorrow evening. And then the rest of the NCAA will realign. And I believe that's going to occur in 2027. So a lot of what happens here this week with regard to this decision is going to, eventually lead us to 2027. Let's get back to...
You can remain seated and come to order on the interim breaks. So I said I would start next with the unrepresented objectors, of which the first on the list is Gannon Flynn. Mr. Flynn here and his.
Good morning, Your Honor.
Good morning.
First, I'd like to thank you for allowing me to be here today.
You're welcome.
Throughout this hearing, we've already heard from a lot of lawyers discussing the legal implications, but I want you to have the viewpoint of an athlete. On October 6, 2023, I committed to swim for the University of Utah. Instead of entering college with excitement for the next 4 years, we entered gripped by fear of the incoming roster cuts. We're currently in an era where if you're an athlete, you cannot be human. No mistakes, no injuries. If you don't have a perfect season, you might not get another. With the incredibly restrictive roster limits coming into play, coaches are informing athletes that they should either try and transfer or quit outright. Even athletes with recoverable injuries are being told that their dreams are no longer reality. Athletes with recoverable injuries are getting cut simply because coaches don't want to risk waiting for someone to recover, even if they have the same potential. Athletes are being cut because they fell at the start of the year and broke their elbow. They tore a tendon in their ankle and needed surgery, or had a fracture in their spine because their teammate kicked them a month before conference. Each of these athletes failed to perform their duties because of an injury. And because of the settlement, they find their athletic careers completely devastated. These roster limits that are being placed on our sports aren't just restrictive, they're cruel. Every day, athletes are being cut in anticipation for the settlement, blatantly contradicting the plaintiff's claims that athletic participation will not be affected. Using data from the United States Department of Education's Equity and Athletics website, I was able to get the most recent data for Power 5 athletic participation numbers in March from the 2022 fiscal year. Using the roster limits going into effect from this case, I totaled up how many people would get cut. This does not take into account universities cutting entire programs or conferences setting lower roster limits such as the SEC. At least 325 athletes are going to be cut from the likes of hockey, men's gymnastics, golf, men's volleyball, women's lacrosse, equestrian, water polo, fencing, and beach volleyball. But the numbers don't stop there. In fact, they just keep getting larger, with 48 from women's softball, 59 from men's lacrosse, 65 from men's basketball, 68 from women's volleyball, 83 from men's soccer, 92 from women's gymnastics, 149 from men's wrestling, 172 from men's swimming, 240 from women's swimming, 348 from women's rowing, 391 from men's baseball, 442 from women's basketball, 443 from men's track, 825 from women's track, and 1,253 from football. In total, at least 5,356 Power 5 student athletes will lose their roster spots due to the settlement. Your Honor, at the preliminary approval hearing, you said, quote, "I found that taking things away from people is usually not too popular," end quote, regarding the original proposal of taking away NIL collectives. Well, what about my roster spot? What about our ability to even compete? We're not here for money. We're student athletes. We just want to play and compete. On paper, this settlement might look good, but when you step out of the law offices of the lawyers who drafted this and talk to the athletes who they are supposed to be representing, you see something completely different. Thousands of people are losing their spots and scholarships. On paper, no more scholarship limits sound great, but schools aren't awarding more. For example, TCU's athletic director said in an interview that they are considering reallocating scholarships. They plan to remove scholarships from the Olympic sports to give more to the revenue generating ones, which again hurts the majority of people who just want to compete. In a podcast with both lead counsels, Jeffrey Kessler, the lead lawyer for the plaintiffs, was discussing the possibility of schools cutting programs and was very adamant that they wouldn't. He said, quote, "That doesn't mean, by the way, that there might not be some sport cut in the future, but it will have nothing to do with this settlement," end quote. However, the week that the motion for final approval was filed, California Polytechnic University announced that it was cutting its men's swimming and diving program effective immediately. The University of Virginia is also cutting their diving program. The situation at Cal Poly highlights a fundamental issue with forcing the NCAA to abandon its amateurism model. This settlement that disregards that principle brings a $20 million issue to the forefront. This settlement would allow colleges to pay around $20 million annually, with that figure increasing each year. Yet, these are nonprofit institutions that are legally prohibited from carrying large cash reserves. They are now faced with the impossible task of either making drastic budget cuts or somehow gaining massive new revenue streams. We've already seen the consequences of this pressure from Cal Poly, where non-revenue generating sports were cut just to keep the revenue generating programs happy. This decision doesn't just harm the majority of NCAA athletes, it also threatens their nation's future Olympic teams, with 75% of Team USA consisting of current or former NCAA athletes. This settlement would kill the pipeline that feeds the largest and most prestigious sports competition in the world.
I'm going to give you a minute to finish up.
Okay. As revenue generating athletes demand more money, we're going to see schools cut more and more programs to come up with that money. Eddie Reese, one of the best NCAA coaches of all time, who led the University of Texas to 15 NCAA titles and 45 consecutive conference swimming and diving titles, said presently there are over 140 men's Division I swimming and diving teams. Based on all of his knowledge and experience, he believes that this settlement will cut it down to under 50. I've spoken about swimming because I'm a swimmer and I know the sport best, but the objections to this settlement are not limited to swimmers. They come from the athletes across many sports, many who chose not to submit written objections out of fear of retaliation from coaches or athletic departments, while many others simply didn't know they could object at all. The written objections are just a fraction of the reality. I wrote my objection letter back in January before I knew whether Utah would keep me on the team next year. My views on this case are not about my own position, they are about the principle. Because at the end of the day, if I stay, someone else will get cut because of this settlement. The community that tens of that.
Thanks for coming in.
Thank you, Your Honor.
Gracelyn Loudermilk.
Good afternoon, Your Honor. My name is Gracelyn Loudermilk. Thank you for reading my objection letter and granting me the opportunity to share my story. I stand here alone today without an attorney because I had no one representing me or my interests in this settlement. I believe this settlement is unfair. The roster limits destroy the hard work and dreams of thousands of student athletes like me all over the nation. Your Honor, roster limits should not be a facet of this settlement. The settlement payments are also a slap in the face for girls and women. While those payments are going to past athletes, they tell a story to every girl, reinforcing the myth that they are not worth as much as men. So I ask, why are we allowing the NCAA to make a civil rights decision of regression oppressing girls and women? My dream to compete in Division I athletics began in 2019 when I fell in love with the sport of cross country and track. But nothing about this dream has come easy for me. This dream led me to devote 20 plus hours a week to my sport, in addition to maintaining a 4.0 GPA and taking dual enrollment college classes. Running has become my most demanding teacher. After having 4 stress fractures in my foot my freshman year, I realized that for this opportunity to be sustainable, I'd have to take a slower progression on my road to success. But by God's grace, I have been able to reach many of my desired stepping stones. I'm a 4-time state medalist and an All-American. I hold numerous school records. In my junior year, I reached what on the website of the universities I was looking at, I met their times for their roster positions. I met the times that I needed to be an athlete at the schools that I desired. And I began my senior year. I was on course to attend my dream college. I was so excited. My 14-year-old self would have been so proud. But then came the House versus NCAA case, and all of my plans came to a halt. I had been in contact with 5 Division I schools and 1 NAIA school. I went on 3 college visits, and I carefully made my decision. My other offer deadlines came, and I politely declined them. My dreams, prayers, and hopes were becoming my reality. I was so excited to have the opportunity to train in impressive facilities under outstanding coaches with amazing girls who had the same high goals as I did. This small-town girl with big dreams would finally have the opportunity at the highest level of collegiate sports. I made the call to commit. It was October 30th, 2024 at 4 p.m. Then the coach compassionately informed me that mere hours earlier, she had been informed that their university was opting into the settlement. She wasn't even sure how many girls she would have on the roster in the fall. She assured me that this wasn't her heart. She didn't want to cut her girls. She didn't want to rescind roster spots to recruits. I hung up the phone and I cried. I cried for the hours I had spent cross-training. I cried for the innumerable numbers of times I got back up, for the times that I believed it would be worth it. I cried for the dream I had. I cried for the uncertainty of the future. I cried for the way my dream was being ripped away from me. I still cry because it still hurts. I'm not the only one. I represent thousands of student athletes struggling to find our place. For many adults involved in this case, that number is just a number. But when I hear it, I can see the faces of my friends and competitors. I hear the pain in their voices and see the uncertainty in their eyes. No one can explain to us why roster limits are good for anyone. Your Honor, the settlement also impacts me. This settlement has made us scared to hope and afraid to dream. We're a group of 16 to 22-year-olds having our futures decided without representation. It has been very challenging not to let the drama of this case and the uncertainty of our futures derail our everyday lives. Our futures are being held in your hands. Please, Your Honor, can you help us understand why the colleges are banding together to limit how many of us get to compete? This settlement also impacts me because I'm a girl. My dreams have been fueled by the groundbreaking advancements being made in women's sports. This progress has given me so much hope for myself, my younger sisters, and cousins. This settlement will affect thousands of girls younger than me. It is not just an NCAA settlement. This settlement would tell the story to me and every other girl that we don't deserve the same as boys and men. How could a just court possibly tell girls and women, you aren't worth it and you don't deserve the same as men? One runner story that has inspired me is that of Emily Mackay. She grew up about an hour from my house, and I have high school racing times almost identical to hers. She went to a D1 university where she was developed into a world-class athlete. She's now a professional runner, a world's bronze medalist, and an Olympian. This is just one of the examples I could share showing that slow progression is not an indicator of lack of potential. Isn't that good news for a lot of us? But if this settlement had gone into effect when she was a senior in high school, would there have even been a roster spot for her? She is an example of what athletes like me could become if given the opportunity to have a roster spot, to find my peak, and to develop at the highest level of collegiate sports. Please do not delay, Judge Wilkins. Just the potential outcomes of this case have already obstructed the planning of high school athletes across America for the past 6 months. Your decision on this case will decide the fate of countless student athletes. The NCAA student athletes need answers. My class of 2025 needs answers. The future student athletes need answers. The coaches need answers. The parents need answers. Your Honor, please deny this settlement and allow us to chase our American dreams in Division I athletics by eliminating roster limits and upholding equity in sports for girls and women. Thank you for this opportunity to share my story here today.
Thank you for coming in.
Yeah, thank you.
Olivia Dunn. Oh, I think she was going to come on Zoom. Is she
Yes.
on Zoom? Oh,
Yes, I'm here on Zoom.
oh, okay. Let me find the Zoom. You're the first one that's been on Zoom. Okay, it's only on a little small thing and not the big thing, but that's okay.
Okay. Your Honor, my name is Olivia Dunn. I'm a Division I athlete, a businesswoman, and I've been the highest earning female athlete since the NIL rules changed. I'm here today because the NIL opportunities I worked for were delayed by NCAA rules, and this settlement doesn't come close to recognizing the value I lost or the value so many other athletes like me were denied. The NCAA says 99% of student athletes won't go pro, and I'm part of that 99%. That's exactly why we should have the same opportunity as any other student on campus to build a business, grow our brand, and monetize our skills while we're in college. I've shattered expectations and consistently surpassed industry NIL projections, yet every year, those projections have underestimated my actual earnings. That's not just a personal detail, it's a warning sign. When a settlement uses flawed data to cap damages, it risks undervaluing the very athletes it claims to support. NIL isn't just about income, it's about fairness, independence, and the freedom to create a future beyond sports. These are some of the objections I have to the current settlement. The damages formula is unclear. When I first tried to see my damages estimate, the site didn't work. I was trying to decide if I should opt in or sue on my own, but I couldn't get the information. The link just kept looping. Around January 31st, 2025, the NIL lookup results finally worked, and I was able to see the data submitted by my school that supported my estimate allocation. But that information wasn't correct. It didn't match what I actually earned. I had to opt in just to submit more accurate data. The number I saw didn't come close to my actual NIL value, but to submit any correction, I had to opt in, locking myself into the settlement's terms. That wasn't meaningful consent. That was a contract of adhesion. I had to agree, just to try to be treated fairly. I submitted my real NIL data, but heard nothing back. I submitted actual financial information from NIL deals I had secured. Those deals were public-facing, legitimate, and documented, but I received no confirmation, no updated estimate, no acknowledgement that my data was even seen, let alone considered. Worse, the site was requesting I submit private contract values without any clear assurances that those documents would be kept secure or respected under my NDAs. There was no way to review or object. Even though I knew my number was wrong and I had the proof, there was no process to challenge or revise it before the deadline. That left athletes like me who had strong NIL value with no voice and no options. And for those who might ask, why didn't you just sue separately? That would have required access to accurate, timely information, and I didn't have it until it was too late. My value existed before NIL was legal. I don't need to guess what I might have earned. I know. I had a growing platform and millions of followers before I ever stepped foot onto a college campus. Brands were interested, followers were engaged, demand was real. Had NIL rules not restricted me, my value would have started higher, scaled faster, and grown even more, including during high school, when I was already amassing a large following, but couldn't earn money without compromising my NCAA eligibility. That lost momentum matters, and it's been ignored. This process lacked transparency. We were told to trust the system, but the system didn't communicate. I sent multiple emails. Answers were vague. Critical information wasn't available until the very last day. Meanwhile, lawyers may receive hundreds of millions in fees, and athletes like me still don't know if our data submissions were even considered. NIL is bigger than sports, and this settlement misses that. This entire process defines athlete value based on the sport you played and how much revenue your team brought in. But NIL is about more than wins and revenue. Sometimes the athlete most harmed by these rules isn't the star of the team. Sometimes she's a freshman, she's a gymnast, a young woman with a phone, a dream, and the discipline to build something that challenged the norm, even when the system said not yet. This settlement uses old logic to calculate modern value. It takes a narrow snapshot of a still maturing market and freezes it, ignoring the trajectory we were on and the deals we lost and the future we could have had. Your Honor, I ask the settlement not be approved as it stands, not just for me, but for every athlete whose NIL value was real, but invisible. We deserve more than an estimate. We deserve to be heard, to be seen, and to be compensated for the value we created, not just the value the system was willing to measure. Thank you.
Thank you. If the settlement isn't approved, then there won't be a question of opting in or opting out or how much it's supposed to be or anything else. But if the settlement is approved and you're not happy with, if you think mistakes have been made or you didn't get your phone calls returned or whatever, I'm sure that we can, if you'll try again, call the settlement administrator or plaintiff's counsel, they will at least respond and let you know what the deal is. Okay, thanks for coming in. Or you didn't come in. Thanks for appearing on Zoom.
Thank you so much.
Mr. Burr-Curvin.
Good morning, Your Honor.
Good morning.
Thank you for the honor and privilege of addressing the court. My name is Benjamin Burr-Curvin. I'm a former first-team All-American linebacker for the University of Washington football team. I played there from 2015 to 2019, and 3 of my 4 seasons were covered by the damages class. In my senior year, I was the leading tackler in the nation. I was also the Pac-12 Defensive Player of the Year, Pac-12 and Pac-12 Scholar of the Year, which is the first time a football player received both awards. During my relevant playing years, we won the Pac-12 championship twice. We went to the Rose Bowl and were ranked 4th in the nation, earning a spot in the National Football Championship semifinal. My senior year, I was the most decorated player on the UW football team. During my time at UW, NCAA rules prevented me from capitalizing on, from what I can see, would have been significant earnings from NLI. My team was highly successful and regularly played in nationally televised games that had large viewership, and personally, because of my performance, I had a large fan base. I was well known and recognized not just in Washington State, but throughout Northern California where I grew up. Because of this, UW featured me in promotional and fundraising materials and still does. Yet under NCAA rules while I was in school, a friend who was alum could not even buy me a hamburger. I'm objecting to the settlement for 2 primary reasons. 1, the method used to determine the payouts is a cryptic black box. It fails to account for differences in athletic performance and has resulted in illogical and highly unfair estimated payouts. 2, the damages settlement class unfairly treats decorated athletes like myself. We missed out on lucrative third-party NLI financial opportunities due to NCAA rules, yet we are ineligible for third-party NLI payments in the settlement. First, the black box determining the allocations. I understood from the plaintiff's attorneys that NCAA athletes like me would be compensated based on the sports we played in and its contribution, and our performance, contribution, accolades, and success would be significant factors in determining payouts. This is apparently not true. From what little information I have been able to dig up on my own, the payout scheme is totally illogical and inconsistent. In my letter objecting to the settlement, I outlined several specific examples that illustrate the unfairness of the payouts. My estimated payout is about half that of several teammates and fellow football players, all whose relevant playing years exactly mirror my own and who did not achieve the levels of performance on the field that I did. My estimated payout is the same as a walk-on player who rarely played in games. For example, it is 0 compensation for athletic services, while teammates are receiving significant payouts in that category. When I raised this with the plaintiff's attorneys, they offered no clear explanation. The payout amounts that I've been able to dig up are all different amounts, and there is no way to make sense of them. So either the algorithm is calculating nonsense, or the data input is inaccurate. Either way, there is clearly a problem, and there is no way to audit the amounts to ensure fairness and logic. Second, regarding lost NLI for high-performing athletes. As an NCAA athlete before the NLI era, the unfairness to me and those like me is stark, compared to those players who were lucky enough to receive third-party NLI payments while they were in school. I engaged in all the same activities and played just as hard as NLI era athletes, but they're eligible for lost third-party NLI payments in the settlement, and I am not. One example includes a UW special teams player who graduated in 2022 and was awarded nearly 5 times my payout as a result of lost NLI. I think most people with even a basic understanding of football would be shocked that a special teams player would be paid out 5 times that of a starting linebacker with my level of performance. I do not see how that can be remotely considered fair. The logic is circular. You can only get compensated for lost third-party NLI if you actually got third-party NLI. This model is discriminatory against me and other athletes who simply had no access to third-party NLI, but still incurred the damages. As I understand it, this is a violation of Rule 23. Why is this the case? The best I can decipher is that the plaintiff's attorneys are dodging responsibility for this unfairness by hiding behind the experts they hired. I am not an expert, but I can tell when a system is unfair. I'm sure there are many ways to fairly and reasonably treat the damages class, including a simple point system for national and divisional accolades. Plaintiffs' attorneys have said that those of us who are objecting can leave the class because there are hundreds of thousands of athletes who are not objecting. I can only say that if former athletes had the time and resources that I've had to dig into this, they would probably be equally alarmed. The plaintiffs' attorneys are banking on former athletes not having the time or resources to dig into the unfairness of this proposed settlement. I feel that in many ways I'm speaking for many of these thousands of athletes. NCAA athletes know what it's like to work incredibly hard, to spend hours and hours on what may seem like small details, because details are the difference between victory and defeat. We were never satisfied with what is good enough. All of us balanced a full academic workload in addition to full-time commitment to athletics. Our colleges and universities richly profited from our efforts. Your Honor, I urge you to direct attorneys to go back and do the work. I know they are eager to have this over with, to get their fees and move on. But like these athletes that did not just stop at good enough, I'm asking the same of the attorneys. Plaintiffs' attorneys need to work on a fair settlement worthy of the phenomenal athletes they represent. Thank you.
Okay. Well, again, if the settlement is not approved, then it won't matter what the calculation was,
Yeah.
because no one will get anything. But if the settlement is approved and you feel that an actual mistake was made as opposed to disagreement with the values and so on, then I'm sure you could contact the either the
We've tried that
attorneys
and been unsuccessful.
or the settlement administrator. Well, if the settlement is approved,
Yeah.
you should try again.
Okay. Thank you so much.
Thanks for coming in. Okay, so let's go back to the council list, and the next person on the list was Mr. Bradford.
Hello, Your Honor. Pat Bradford from Bradford Edwards on behalf of Black athletes, Charles O'Bannon Jr. and Kay Braden Anderson. It's difficult following these sterling students, but I'm going to try to do my best. Thank you for allowing me time to speak.
Is Mr. O'Bannon here?
No. He's in Europe, trying to get to the big game. Let me begin by trying to address a couple of the specific points that Your Honor raised at the beginning. With respect to future classes, plaintiff's counsel says that they were represented at some point, but the concern is, can a junior high school, a future D1 athlete, junior high school now, who is going to become a D1 athlete, can he or she actually release their rights? And what in the settlement helps protect their rights? I think that was Your Honor's question. My understanding is that the answer is provided by Section 14 of the settlement agreement, which says that as soon as the high school student who is going to matriculate at a D1 school gets their packet of information, they will have the ability to read a piece of paper and then opt out within 60 days. In our initial...
No, they can't opt out. They can file an objection.
Exactly.
And we don't know what the mechanism would be if there was an objection. And that was one of the things
Exactly, Your Honor. Thank you. They can object. but to what end? They can say that they don't like the settlement, but there are two issues, and Your Honor has actually corrected me and raised the most important one, which is what happens if they do object. But there's a predicate issue here, which is the 60 days. Eager young incoming freshmen are thinking about a whole lot of things. When they get that piece of paper, they're probably going to ignore it. I think as a practical matter, 60 days just isn't enough to protect their rights, because if they don't do anything under the settlement, they've released their rights. And that's a major concern. So I just wanted to hit that specific issue. A couple of the
They
students
don't really release their rights. They become members of the injunctive relief class if they get in a school that's a D1 and they get on a team that's.
and they don't object.
It doesn't matter if they object or not. If they're,
Yes, Your Honor.
I mean, if they object and there's a proceeding and the new facts are brought to the court and the court says, you're right, it's inflation has hit harder than we thought or less hard than we thought or whatever. Presumably the idea is it would be changed, but
Changed by whom? That's the question.
by the court.
And changed under the advocacy to the court by whom?
I've forgotten that one. Tell me.
No, it was rhetorical because I think it's plaintiff's counsel,
Maybe
and I think that
their class counsel, it would make sense, but I don't know if that's.
and I think that the issue there is the question is whether or not these counsel who have been conflicted, at least that is our position, because there are so many classes here under the case law, including the Second Circuit payments case. There should have been separate representation here. What you've identified as the future classes is just one example of that. My clients come under the Carter payout, $600 million. I'm still trying to get my mind around how an amount that is supposed to be for actual compensation, just charging that $600,000 for the time period and the players, at least originally in Carter, which is about, I think, 19,000. Then they loaded it up so they could say, oh, we need to settle it because it's too numerous. How that could be 600 million and you have payouts over 10 years of what they say is 20 billion for NIL, expressly not compensation, and the annual amount there is 2 billion.
Those numbers don't sound right to me.
Well, I'm sure.
Let's talk about the point.
I'm sure
interested
that
in your thoughts. You were one of really two who addressed the problem or the potential problem of future class members, both being members of the class and having a release, they don't sign it, but having their situation released. And I'd be interested to know what you think would be better. I mean, we can't help it that somebody who's 10 years old can't be told whether they're going to be on a football team or not. That's just not possible. So what's the best way? And yet, on the other hand, we don't want to say, oh, 10-year-old, you don't get the benefit of this because you weren't around when it was had. That's not the solution either. So I just was wondering what you thought the right solution would be to make sure that future student athletes, when they became known, would get the benefit of the injunction.
Your Honor, at a minimum, because I'm not prepared to sort of, give you chapter and verse now, but at a minimum, it would require more than 60 days. And at a minimum, it would require that the settlement provide enough substantive procedures so that the individual future athlete would understand meaningfully what their objection, if they were to object, what it actually means. Right now, the settlement doesn't answer the question. The time is too short and
it's sort of necessary though. When do these players start playing? They start pretty much right.
Your Honor, you realize that the notice, you realize that the 60 days comes even before they walk through the door.
Right.
They get a package. It's thick. right? They're thinking about all these things. And as a practical matter, 60 days is not going to be enough for the average freshman to consider that with all the other things she or he is thinking
So
about.
they get their packet. Is it still April 1st? Well, that's just for admissions. I don't know when they tell them what they're on a team.
Yeah. We suggest in our first brief, we
6 months is way too long. The season
suggest
would have started by that time.
we suggest in our first brief that it should be 6 months from the time they matriculate, not when they get their package
But
beforehand.
then the season is over.
They can play. They can play.
Oh, okay.
Your Honor, we've also addressed this issue of the glitches, and every time a student or someone says, I wasn't able to register, one of my clients wasn't able to register,
If you have other points, the glitches is just not worth
well, just one
spending a lot
point.
of time on.
No, just one point on the glitches, Your Honor, and I do appreciate it. You suggested that the glitches can be corrected and will be corrected, but there's nothing in writing that says that. And even right now, they say, oh, don't worry about the D1 basketball and football players because they didn't actually have to register. All they had to do was go on and correct their information to get paid. Question: those D1 players who didn't have to register to claim, if they didn't go on and give their information, try to correct their information and give their payment method today, can they do that now? Your Honor,
There's some talk of that, yes.
Yes.
And I'm
Yeah.
hoping,
Yeah.
I know the plaintiffs are prove it. I haven't heard from defendants yet, but it's on the table anyway. I'll ask about it.
Well, Your Honor, this goes to a major point why I wanted to thank you, because you began the hearing by saying that there are a list of concerns that you have and that you have an open mind. Counsel for the NCAA basically said, we aren't here to have Your Honor consider any changes to this proposed settlement. It's an all or nothing thing. And if that's correct, then it's nothing. But as we point out in our second brief, and I do apologize for getting it in late, and I do thank Your Honor for taking time to read it, but we do point out that the case law, while it doesn't allow Your Honor to become scrivener and change the agreement, you certainly have the authority to make suggestions and send the parties back to the table to clean up some of these obvious problems. Your Honor, I just had one other point that I wanted to make.
Okay, do that because we're pretty much out of time.
Yep. One of our main concerns is about the single counsel representing class members with fundamental conflicts. If the possibility of trade-offs, we're concerned that counsel cannot adequately and vigorously advocate for one set of class members or one set of claims. We've distinguished in our briefs, including the belatedly filed second brief, all of the cases that they rely on for this idea that because they segregated the negotiation, that somehow that cures the problem. Their answer is to go to the end of the process and say everybody's getting something, but that's not what Rule 23 requires. You got to look to see, was there adequate representation of the individual class members and of counsel? And here, we think that the Second Circuit's decision in the credit card case is the closest case to this case. And so
That case said it's not an ironclad rule, that in that case, there should have been separate counsel, but they were at pains to say that isn't a rule. It doesn't always have to be separate counsel. And we look at the facts about how the thing came out and see if there's evidence that there was some sort of
when you look at the evidence
decision
here,
making.
and when you look at the evidence here of how things came out, what do you see? You see, one, that pay for play claims were valued at $6 million. You see that $600 million. Excuse me, Your Honor. Correct. $600 million. You see that future claims expressly not pay for play are $20 billion over 10 years for the schools. And this is important because the trade-off is right in the record. This whole process began, and The relevant document is the joint declaration of Mr. Berman and Kessler, which is 494-1 in the record. Paragraphs 9 and paragraphs 14 and 15. It basically says that the NCAA wasn't going to settle just the NIL piece. They had to have the other piece. So from the beginning, as counsel for the NCAA said, this was carefully, every piece is involved. And so the real question is, given what is in the record about the evident trade-offs, which was the genesis of the entire deal, pulling in Carter. And of course there are trade-offs because there were two separate cases with two separate classes. So how couldn't there be conflicts? Nowhere does anybody explain, not plaintiff's counsel or the NCAA, why they didn't simply bring in another lawyer or group of lawyers to protect the rights. We're here because the trade-offs that have resulted in this proposed settlement demonstrate that unitary counsel was inappropriate, and perhaps more equally importantly, because this settlement doesn't simply activate itself. So many provisions of the settlement require plaintiff's counsel to remain involved in its implementation. So, for example, Article 6, enforcement.
We can't go into this level of detail. If you have an overarching point you'd like to end with, I need to ask you.
I'm sorry, Your Honor. The overarching point is simply this. If we get it wrong with respect to unitary counsel, we get it wrong not just for the instant, we get it wrong potentially for the next 20 years. Because
10.
The proposed settlement says, I believe in Section 9, that at the end of the 10 years,
Oh, there could be extensions, true.
the plaintiff's counsel and the NCA will get together and decide for all of these kids, who some of them aren't even born, whether or not this thing still stands. And all I'm saying is a significant point to consider is simply that if we get it wrong with respect to whether unitary counsel should have been permitted here, with the evident trade-offs that are on the record, we don't get it wrong just for the instant. We potentially get it wrong for the next decade or two.
Okay.
Thank you, Your
Thank you
Honor.
for coming in. Is it Ms. Friestad? No, it's Mr. Friestad. Go ahead.
Good morning, Your Honor.
Good afternoon.
May it please the court, my name is Lee Ernst Friestad, and I'm here on behalf of 4 outstanding female student athletes, 3 of whom who are currently still in college. Charlotte North is the #1 women's lacrosse player, not only in this country, but in the world right now. She graduated.
Okay, I'm going to give you 10 minutes.
Yep, no
So I
problem.
think
So let me just,
on those details is
okay.
access to you.
great athletes. I hear you, Your Honor. They are objecting on behalf of Title IX, and they are objecting because they have realized what an important means to be an equal opportunity and the benefits that they have found from being an exceptional student athlete. In particular, they are concerned that this settlement is giving $2.4 billion to men and $102 million to women. That seems to be a glaring sign of a disproportionate amount.
Well, the problem with it is that money, I think, is what you're referring to, is the money that is damages for the past. The past antitrust violations.
Sure.
And past antitrust violations hit men because men were the only one who were standing to make money at that time. So you can't turn back and say, oh, it should be different. You can't solve all these problems retrospectively in the current antitrust problem. So it's too bad, but
So thank you, Your Honor, for
have
that.
an argument about how Title IX would apply and what effect it could have in controversion of what I said earlier and what some of the others have said. If that would be helpful, but You
So-
can't change the past.
Sure. I guess the one point I would bring forward is under the class council model of the but-for, it does assume that these payments would have been permitted under Title IX. And one of our theories is that in the but-for model, that these payments would not have been permitted under Title IX because they would have been coming from the universities themselves. And under the equal opportunity parameters of the Title IX regulations, they would have fallen under the concept of a financial assistance or benefits. And getting to the second point, Your Honor, to the extent that I understand that this is an antitrust case and we want to move on from the Title IX issue, I would respectfully request that this Title IX release language that is currently in the settlement agreement and has been restated in a slightly different way in more recent filings by class counsel.
What was the difference?
I would be happy to read you the
Adding the
difference.
phrase or was?
Sure, I'd be happy.
Phrase?
Yes, so the under the settlement agreement, unreleased claims is stated as claims under Title IX other than any claims arising out of or relating to the distribution of the gross settlement
Right,
fund.
that's the current language.
Correct.
What was it?
So in the more recent language, and this
That's
is
the current language.
that's correct, Your Honor, that is in the settlement agreement. But in reading document 717, plaintiff's motion for final settlement approval and response to objections, they have stated there is only a very narrow release of the Title IX claims, quote, arising from distribution of the gross settlement agreement. So it's slightly different words. And then there's a second reference on page 45 of the same document.
I'm not seeing the difference. I mean, I don't have it in front of me, so I can't remember it, but that sounds like the same thing.
I think if you look at the words carefully, Your Honor, my concern is
Okay,
that,
I'll look at it later.
Okay.
I don't have that right in front of me, and I've got too many papers to find it, so
understood.
we'll check into it.
Sure. I mean, the two pages that I would reference then are page 62 and page 45 in document 717.
Okay.
I guess in terms of the release itself, Your Honor, too, we are concerned that this encompasses not only the NCAA, the conferences, but also the universities. And again, that it encompasses not only the back payments here, but also, again, the future injunctive relief as well. And so really, to the extent that the women are not in a position to have the merits of the Title IX issue addressed here, we absolutely request that the Title IX release not carve out the ability for them to contemplate, future action if necessary. In terms of other important things we wanted to address is we have a concern that there is a conflict of interest, which my clients have all stated in terms of the representation of class counsel here. Specifically, the conflict is very simple. The class counsel does not think there's a Title IX issue. Clearly, my clients do. That's a fundamental issue. Right now, the calculations did not factor Title IX into the analysis. We think they should have. The NCAA and conferences, according to class counsel, are not covered by Title IX. We think that they are covered by Title IX under analysis of NCAA versus Smith. So just to give you high level some of our concerns when we look at the adequacy of class counsel representing not just my clients, Your Honor, but also the entire subclass of women here. In terms of some of the procedural things that a lot of other people have asked as well, I would simply say that my clients also experienced all the difficulties on the websites. I would also say that all 4 of my clients were not properly notified. One of them believes that her dad did receive a postcard, but otherwise 3 of them who are current student athletes did not receive any sort of electronic notification. In terms of trying to get the accurate information, all of them had inaccurate information. It was impossible for us to get that updated. Some of it was completely missing from universities. And the order of magnitude too, for one of my clients, Your Honor, she earned $118,000 from when the Alston decision was made until her final year. And for example, her school only recorded that as being one $1,000 payment. So that would be an example of how the numbers just really did not work. And we have repeatedly tried to update that. So to the extent you could help us with that, as I understand you're assisting with other people, we would greatly appreciate that.
I'm not assisting other people other than saying, try again.
Okay, okay, that's fine. So I guess in closing, Your Honor, I just, again, on behalf of my clients, we're advocating for an equal opportunity for women and girls, and not just the current women who are playing sports, but future women as well. And I think that it makes a huge statement when we say that the women are worth $102 million and the men are worth $2.4 billion. I know you don't want to go into the merits of that calculation, but I do think it is fundamentally flawed. I do think if you look at it in a but-for world, those payments would have been covered by Title IX and they never would have been permitted. And therefore, those 2.4 and the $102 million would in fact constitute a Title IX violation. Thank you, Your Honor.
Okay, thank you. I'm going to break for lunch at 1, so I think we have time for one more person, which would be Mr. Ford.
Thank you, Your Honor. My name is Richard Ford, and I'm here on behalf of myself, Michelle Roberts, and Casey Floyd. We filed a letter with the court. It was in the nature of an...
I'm confused. Is one of you an attorney representing someone?
No, we are not.
An attorney, or
we are... I'm a recovering attorney. I don't practice now, but we are not representing any athletes, any class members. We filed a letter.
Yourselves, class members?
No, we are not.
Oh, well.
Yes,
You're here now.
we're here now. Yes, from the East Coast.
We wouldn't have included you had we known that. This portion of our program was objectors' attorneys who had clients who were class members. So, but you're here, so go ahead. What did you want to say?
Thank you, Your Honor. We submitted a letter that was in the nature of a friend of the court brief, and we addressed a number of issues. What I would like to do, Your Honor, is talk a little bit about Article 7 of the injunctive relief settlement, the legislation and alternative structures. You mentioned it, it's on your list, and the notion that the class counsel is required to lobby with the defendant.
Lobby is not used.
Okay, they are required to cooperate with and support legislation that aligns with what the defendants have been asking for really since 2019. And it's important, Your Honor.
Well, that's not what it says.
But the context for it, one of the reasons we submitted our letter, Your Honor, is that Article 7, it really doesn't make much sense unless you understand the congressional campaign and the NCAA's goals. And
nobody has missed that.
Excuse me, Your Honor?
No one has missed the desire of the NCAA to get an antitrust exemption.
And preemption, and a provision that says that athletes cannot, as a matter of federal law, be employees. And
okay, they can ask whatever they want.
Yes, but the question, Your Honor, is should class counsel support them in those congressional initiatives? And we believe that class counsel support on those core issues that really go to the fundamental rights that athletes have in this system is unfair, unreasonable, reflects inadequate representation, and is entirely outside the scope of the settlement or the underlying cases. Preemption and the labor issues have nothing to do with the underlying cases. And one of the questions I had when I first read the settlement document, Your Honor, is why is this provision in the settlement agreement? And I think we have to zoom out and look at what the NCAA and Power 5 have wanted all along. And it's absolute regulatory supremacy over college sports. And second, absolute control over the labor force. And by eliminating college athletes' rights under state laws and the protection of state laws, by eliminating their access to free markets and their access to free competition laws, and by eliminating the protection of labor laws because they can't be employees, athletes have no alternative legal or regulatory pathway to protect their rights. So this provision, Your Honor, is a pathway to an outcome that we don't think is fair for the athletes. And, Mr. Berman said, so he talked about the Ted Cruz bill, and that bill is a Death Star for athletes because it would turn them into second-class citizens because it has all three of those provisions: preemption, antitrust immunity, athletes can't be employees. And he has said that if the court does not approve this settlement, then the Cruz bill will be more likely. Okay. I would argue the opposite. I think it's more likely if you do approve the settlement, because then Mr. Berman's going to be required to support the antitrust exemption and to support the antitrust immunity piece. And then you have a really dangerous situation, Your Honor. And Mr. Berman, back in 2020, and this is in the record, Your Honor, at ECF number 613, Appendix B, Mr. Berman said a beautiful letter to Senator Richard Blumenthal, really begging him not to give the NCAA an antitrust immunity. This was 2 weeks after he filed House. It was 2 weeks after Republican Senator Marco Rubio introduced the very first nil bill, which gave the NCAA preemption, antitrust immunity, athletes can't be employees. And he made some powerful arguments. Among them are that the NCAA is making an unprecedented ask that the NCAA can't be trusted with an antitrust immunity because they have used their regulatory authority to mistreat athletes, and that antitrust law is the only pathway that athletes have had to force the NCAA to change. So, giving up that tool, giving up the big hammer that athletes have had and that class counsel have so beautifully used to help athletes, and then eliminating that and then having class counsel work against athletes' interests in Congress, we think would be a tragic outcome. And Charlie Baker, NCAA president, has said, Your Honor, that if you approve the settlement, he and others are going to say, look, a separate branch of government has said that this settlement, and it's
Good. They can say that all they want, but it wouldn't be the case.
But Your Honor, we would
and the way I read what counsel have agreed to do with respect to all these things, and I don't have the exact language in front of me on each of them, and they're somewhat different. Preemption does use the word support.
Support, yes.
I have to use a different word.
Yes, and then
but they seem to me to be efforts to say we won't let our settlement agreement get struck down on any of these grounds, and that just doesn't bother me, because if they are going into the settlement agreement, it's because they think it's the right thing to do, and if they think it's the right thing to do, they don't want it to be struck down as a bad act.
Yeah, may I respond to that, Your Honor?
Sure.
Yeah, that distinction is a very interesting distinction, and it is supported by some language in Article 7 that talks about, reasonable efforts to support the portions of proposed federal legislation implementing or codifying this injunctive relief settlement. That implementing and codifying is a key piece here. We don't have to speculate what implementing and codifying means to the NCAA, because they support the Ted Cruz bill.
They ask for what they want to ask for, but they're not necessarily going to get it. And it's not.
But there's a piece of that, Your Honor, in this distinction between merely asking for protective federal legislation that codifies the settlement versus asking for the blanket protections that the NCAA has wanted all along and has supported, is that class counsel has also promised, Your Honor, not to oppose anything that the NCAA does. That's one of the promises of Article 7.
I doubt that.
Your Honor, it's in Section 1 legislation. Let's see. Okay, here it is. Class counsel will not oppose, advocate against, lobby in any way against, they use the word lobby, or otherwise attempt or seek to undermine legislation implementing, codifying this injunctive relief settlement. That's a promise, an independent promise, which really takes them off the table. And then the only party that's going to decide what is an implementation and a codification are the defendants. And we know what that means to them, because the bills that they have supported, Your Honor, go far beyond the settlement. It's the Moore Fry bill, which they have supported, would give a blanket antitrust immunity. That was rolled out in connection with the rollout of the settlement.
Okay, but the people who will be deciding will be Congress, not the defendants.
That's correct, Your Honor. But then I would ask, why is this provision in the settlement agreement? Why do we need this? It's obviously very important to the defendants. And our concern, Your Honor, and I'll end with this. This settlement is supposed to be industry shaping. It's supposed to be this amazing thing for college athletes. I was a former college athlete, Division I men's basketball player. And I look at this and I think, how would I have reacted to it? And it all looks great on its face, the economic piece of it, but it comes at an incredible cost. That cost is reflected in Article 7. And I fear that the legacy of this settlement, which transcends, the consequences of a federal bill that would transcend the settlement, we'll have a situation when we look back historically in 5-10 years where, yes, athletes may have gotten more money, but the trade-off for that was the elimination of their fundamental rights as Americans. And I don't think that's a fair trade-off. And by approving the settlement without at least some very strong language saying that this court does not endorse the congressional campaign or any of these three specific asks, I think
It's the fallback position of the United States is amicus letter, which the DOJ withdrew theirs too, or just the.
I don't know if they've withdrawn, Your Honor. I don't think
That
they're.
was their language, that the
Yeah.
court shouldn't approve the settlement, but if the court did, the court should make it clear.
Yes.
that The court was not ruling, which the court is not ruling
Right.
on whether this is an antitrust violation or not.
Yes, Your Honor. And we would,
Settlement,
yes, we would
it's a compromise.
respectfully request language to that effect if the court approves the settlement. But we believe this is so unusual, unnecessary, and harmful, potentially harmful to athletes that it's an independent basis for rejecting the settlement.
Okay,
Okay. Thank you, Your Honor.
thank you. It's 1:00. We'll take a break for an hour for lunch, and then we'll come back and start with Mr. Ellis, who's coming on Zoom. Mr. Lamry and Mr. I don't know who it is, somebody from Buckhalter. And then and DePepe, I forgot about DePepe. And then after that, we'll go over some of the more detailed aspects. And I do need you to leave because we're having a little trouble with our equipment. I need to get,
Take everything.
you don't have to take everything, no.
We can leave it here?
Yeah.
Okay, thank you.
Well, I mean, I'm not going to be at the door. It's at your own risk. But as far as I'm concerned, you can leave it there.
Okay, so I'm going to pause this, obviously. For those of you that are still watching or will walk in the future, we're going to pause for an hour. Really interesting dynamic, couple of things, points being made on not only current athletes, but future athletes. Obviously, those that are currently college athletes, freshmen through juniors, that will obviously be a part of this settlement for the next several years of their college career. But also we're starting to hear from the prospective college athletes or the high school athletes and the potential damages or lack of clarity that they are getting and with regard to, their notifications from the universities, from the coaches, and things of that nature. We're going to pick this up in an hour. If you know folks that would be interested in this, I highly encourage them to follow along both on X as well as Facebook and obviously here on YouTube. So we'll be back in an hour. Consider this to be part one of the NCAA collaborative collective settlement hearing so that the judge can either allow the settlement or ask both parties, the NCAA and the defendants, which is Ed O'Bannon and college athlete groups, to make changes. Okay, we'll be back in 1 hour.